I have considered the application of the subject of this ruling, the various responses thereto, the submissions made on behalf of the parties hereto, and the authorities cited. Before delving into the merits of the application, an issue of jurisdiction, in my view, was alluded to, though not specifically. The issue was to the effect that this court has no power to grant conservatory orders where the constitutionality of legislation is under challenge. Nyarangi J.A. in the case of the owners of motor vessel Lelian S versus Caltex Oil Kenya, while citing words and phrases legally defined, held, and I quote, by jurisdiction is meant the authority which a court has to decide matters that are before it or take cognizance of matters presented in a formal way for its decision. The limits of this authority are imposed by statute, charter, or commission under which the court is constituted and may be extended or restricted by the like means. If no restriction or limit is imposed, the jurisdiction is said to be unlimited. A limitation may be either as to the kind and nature of the actions and matters of which the particular court has cognizance, or as to the area over which jurisdiction shall extend, or it may partake both of these characteristics. If the jurisdiction of an inferior court or tribunal, including an arbitrator, depends on the existence of a particular state of facts, the court or tribunal must inquire into the existence of facts in order to decide whether it has jurisdiction. But except where the court or tribunal has been given power to determine conclusively whether the facts exist, where the court takes upon itself to exercise a jurisdiction which it does not possess, its decision amounts to nothing. Jurisdiction must be acquired before judgment is given. In that case, the court further held, and I quote, jurisdiction is everything. Without it, a court has no power to make one more step. Where a court has no jurisdiction, there would be no basis for a continuation of proceedings pending other evidence. A court of law downs its tool in respect of the matter before it the moment it holds the opinion that it is without jurisdiction. Quote, it is therefore from the point of jurisdiction that I intend to start my determination, since without jurisdiction, I have no option but to lay down my tools. In support of this contention, reliance was placed on the case of Kizito Mark Ngaywa versus Minister of State for Internal Security and Provincial Administration and another, and the case of Susan Wambui, Kaguru, and others versus Attorney General. In the Kizito case, Ibrahim J., as he then was referred to his own decision made on the 6th of October 2010 in Mombasa High Court, petition number 669 of 2009, between Bishop Joseph Kimani and others versus Attorney General, in which he pronounced himself as follows, and I quote, it is a very serious legal and constitutional step to suspend operation of statutes and statutory provisions. The course must wade with care, prudence, and judicious wisdom. For the High Court to grant interim orders in this regard, I think one must, at the interlocutory stage, actually show that the operation of the legislative provision are a danger to life and limb at that very moment. It is my view the principle of presumption of constitutionality of legislation is imperative for any state that believes in democracy, the separation of powers, and the rule of law in general. Further, the courts to be able to suspend legislation during peace times where there is no national disaster or war would, in my view, be interfering with the independence and supremacy of Parliament in its constitutional duty of legislating law. I think that I shall hold the same views, and that legislation should only be impugned in any manner only where it has been proven to be unconstitutional, null, and void. Conservancy orders to suspend operation of statutes, statutory provisions, or even regulations should be wholly avoided, except where the national interest demand and the situation is certain. I am still of the view that there is no place for conservatory or interim orders in petitions which seek to nullify or declare legislation, statutes, and constitutional null and void. It is even more premature at this stage, where the application has not been heard or is not being heard, to seek such conservatory orders. The applications must be heard first, unquote. Majanja J. on his part, in the case of Susan Wambui, Kaguru, and others versus Attorney General, expressed himself inter alia as follows, and I quote, I have given thought to the arguments made, and once again I reiterate that every statute passed by the legislature enjoys a presumption of legality, and it is the duty of every Kenyan to obey the very law that are passed by our representatives in accordance with their delegated sovereign authority. The question for the court is to consider whether these rules whether these laws are within the four corners of the Constitution. No doubt serious legal arguments have been advanced, and I think any answer to them must await full argument and consideration by the court. I cannot at this stage make an interim declaration which would effectively undo the legislative will unless there are strong and cogent reasons to do so, unquote. Emphasis seems to have been placed on the underlying sentence in Bishop Joseph Kimani's case. However, it is my view that the Atlanta judge's decision ought to be read as a whole. If that is done, what clearly comes out is that the power to suspend legislation during peacetime or to be exercised with care, prudence, and judicious wisdom, where it is shown that the operation of the legislative provision are a danger to life and limb at that very moment, and where national interest demand and the situation is certain. On my part, I would modify that view by adding to the phrase a danger to life and limb the words or where there is imminent danger to the Bill of Rights, since Article 19.1 of the Constitution provides that the Bill of Rights is an integral part of Kenya's democratic society and is the framework for social, economic, and cultural policies. And Article 21.1 provides that it is a fundamental duty of the state and every state organ to observe, respect, protect, promote, and fulfill the rights and fundamental freedoms in the Bill of Rights. Similarly, Majanja J did not rule out entirely the possibility of grant of conservatory orders. What the judge held was that at that stage of the application for conservatory orders, he would not make an interim declaration which would effectively undo the legislative will unless there are strong and cogent reasons to do so. In other words, where there are strong and cogent reasons, conservatory orders may be granted. Under Article 1 of the Constitution, sovereign power belongs to the people and it is to be exercised in accordance with the Constitution. That sovereign power is delegated to Parliament and the legislative assemblies in the county governments, the national executive and executive structures in the county governments, and the judiciary and independent tribunals. There is, however, a rider that the said organs must perform their functions in accordance with the Constitution. Our Constitution, having been enacted by way of a referendum, is the direct expression of the people's will, and therefore all state organs in exercising their delegated powers must bow to the will of the people as expressed in the Constitution. If anyone is in doubt, Article 2 of the Constitution provides for the binding effect of the Constitution on state organs and proceeds to decree that any law, including customary law, that is inconsistent with the Constitution is void to the extent of the inconsistency, and any act or omission in contravention of this Constitution is invalid. In my view, if the court has power to declare an enactment void and invalid, likewise the court must have jurisdiction in deserving cases to suspend provisions of an enactment if to do otherwise is likely to render whatever decision the court may arrive at a mirage. Our Constitution, for example, in Article 29D outlaws torture, and freedom from torture is one of the fundamental freedoms which by virtue of Article 25 of the Constitution cannot be limited. If Parliament was to purport to pass an act which introduces torture, it would be illogical for the court to stand back and say that it has no jurisdiction to grant conservatory orders. To do so would amount to the court ceding not only its powers, but failing to protect the Constitution as envisaged in Article 21A of the Constitution. What use would a favorable determination of the petition be to the victim of torture if by the time of the determination, the torture has taken place and freedom lost beyond recall? I therefore disagree with the view that under no circumstances can conservatory orders be granted where a piece of legislation is under challenge. Where, in my view, the court is convinced that the orders ought to be granted, I do not see why the court should shy away from doing so. On this note, I wish to associate myself with the holding of Mulenga, Judge of the Supreme Court of Uganda, in Habri International Company Limited versus Kasam, to the effect, and I quote, "The tendency to interpret the law in a manner that would divest courts of law of jurisdiction too readily, unless the legal provision in question is straightforward and clear, is to be discouraged, since it would be better to err in favor of upholding jurisdiction than to turn a litigant away from the seat of justice without being heard. The jurisdiction of courts of law must be guarded jealously and should not be dispensed with too lightly, and the interests of justice and the rule of law demand this," unquote. I similarly agree with this court decision in Riccardi's court, where it was held, and I quote, The general provisions governing constitutional interpretation are that in interpreting the Constitution, the court would be guided by the general principles that 1. The Constitution was a living instrument with a soul and consciousness of its own, as reflected in preamble and fundamental objectives and directive principles of state policy. Courts must therefore endeavor to avoid crippling it by construing it technically or in a narrow spirit. It will be construed in tune with the lofty purposes for which its makers framed it. So construed, the instrument becomes a solid foundation of democracy and the rule of law. A timorous and imaginative exercise of judicial power of constitutional interpretation leaves the Constitution a stale and sterile document. The provisions touching on fundamental rights have to be interpreted in a broad and liberal manner, thereby jealously protecting and developing the dimensions of those rights and ensuring that our people enjoy their rights. Our young democracy not only functions but also grows, and the will and dominant aspirations of the people prevail. Restrictions on fundamental rights must be strictly construed, unquote. In my view, this holding is even more appropriate in cases where the court is called upon to uphold the provisions of the Constitution. Article 23 of the Constitution does not expressly bar the court from granting conservatory orders where a challenge is taken on the constitutionality of legislation. The only rider is that the case must be one which falls within Article 22 of the Constitution. This, however, does not mean that courts ought to readily suspend legislation simply because a challenge has been made to a statute. I agree that that power ought to be exercised very sparingly where the court is satisfied that it ought to be exercised. However, it can be exercised. Whereas I agree that there's a presumption of constitutionality of statute, that is a rebuttable principle. This was clearly appreciated in the case of the Yanabu versus Attorney General, where it was held inter alia, that in interpreting the Constitution, the court would be guided by the general principles that there is a rebuttable presumption that legislation is constitutional. Have the onus of rebutting the presumption rests on those who challenge that legislation status, save that where those who support a restriction on a fundamental right rely on a clawback or exclusion clause, the onus is on them to justify the restriction. I wish to associate myself with the holding of Mbogoli Msaga J in the case of Masharia versus Murade, where he expresses himself as follows, and I quote, "The learned counsel cited several authorities from the English jurisdiction to advance his submission that the courts have no jurisdiction to question whatever takes place in Parliament. Britain does not have a written constitution, hence the sovereignty of Parliament. But in Kenya, we have a constitution whose supremacy, as set out therein, is unambiguous and unequivocal. In a democratic country governed by a written constitution, it is the constitution which is supreme and sovereign. It is no doubt true that the constitution itself can be amended by the Parliament, but that is possible because the constitution itself makes provision in that behalf, and the amendment of the constitution can be validly made only by following the procedure prescribed in the constitution. That shows that even when Parliament proposes to amend the constitution, it has to comply with the relevant mandate of the constitution itself. Legislators, ministers, and judges take oath of allegiance to the constitution, for it is by the relevant provisions of the constitution that they derive their authority and jurisdiction, and it is to the provisions of the constitution that they owe their allegiance. Therefore, there can be no doubt that the sovereignty which can be claimed by Parliament in England cannot be claimed by any legislature in the literal absolute sense, unquote. In the same vein, Nyamu as then was in the case of Republic versus Public Procurement Administrative Review Board, pronounced himself as follows, and I quote, "The reason why this court cannot blindly apply the so-called ouster clauses is that unlike the English position, where judges must obey or bow to what Parliament legislates, is because Parliament is the supreme organ in that legal system. Even there, judges have refused to blindly apply badly drafted laws and have in some cases filled the gaps in order to complete or give effect to the intention of the legislature. In the case of Kenya, it is our written constitution which is supreme, and any law that is inconsistent with the constitution is void to the extent of the inconsistency. Our first loyalty as judges in Kenya is therefore to the constitution, and in deserving cases, we are at liberty to strike down laws that violate the constitution," unquote. And that brings me to the present case. It was submitted that Hon Orengo, Hon Kalonzo Musyoka, Hon Wetangula, and Hon Wako ought not to have appeared as legal counsel in these proceedings based on their positions as public officers. I take it the same position applies to Hon Sijane. First and foremost, this court is not aware of any public office held by Hon Kalonzo Musyoka. With respect to the other honorable members of parliament, the issue was dealt with by Tuyot J in John Okello Nagafwa versus IEBC, where he pronounced himself as follows. And I quote, and as I understand it, the complaint against Hon Orengo is pointed. It is a specific charge that by acting as counsel in this matter and by signing pleadings, Hon Orengo is contravening the provisions of Article 77(1) of the Constitution and Section 26(1) of the Act. The court must examine counsel's conduct in the light of the express positions Section 26(2) above. The onus was on the petitioner to demonstrate that Hon Orengo's participation in these proceedings as counsel A is inherently incompatible with his responsibility as senator, or B will impair his judgment in execution of the functions of his office as a member of the Senate, or C will result in a conflict of interest in terms of Section 16 of the Act. It had been submitted that counsel's participation here will keep him away from his office as a senator, that he would not fully engage himself in the Senate. Evidently, the work of a member of the Senate involves both parliamentary and non-parliamentary business. The work hours for parliamentary business are regulated by standing orders of the House. This court has looked at those standing orders, and in particular Standing Order 30. It seems that even if a member of Senate was to be involved in other business of the House, e.g. committees, parliamentary business may not engage a member fully from Monday to Friday, 8 a.m. to 5 p.m. In respect to non-parliamentary business, this court was unable to find any regulation governing the work hours. The petitioner has not persuaded this court that Hon Orengo has used up public time in preparing for and participating in this election petition. No evidence has been shown to this court to demonstrate that counsel's conduct this far is inherently incompatible or fundamentally in conflict with his role as a member of the Senate. Unquote. I associate myself with the sentiments of my learned brother and only wish to add that in this case the petition was not drawn by any of the said members of parliament, but by the firm of AT Olwach and Company advocates. Therefore, even if the objection was valid, the court would only have been entitled to bar the said members from participating in these proceedings, but not to strike out the petition on the ground of incompetency. Accordingly, I decline to strike out the petition on that score. It was submitted that these petitions ought to be allowed on the ground that the petitioners have opened two fronts in their battle against the Act, since they are challenging the Act before this court as well as before the Senate. Again, whereas that contention may apply to the first petitioner's petition, it may not necessarily be correct with respect to the second petitioner's cause. It was not shown that the second petitioner, a constitutional commission, has challenged the Act before the Senate. It would therefore be unjust to throw out the whole case on the basis of an alleged abuse of the legal process by the first petitioner. Article 165(3)(d)(2) of the Constitution donates to the High Court the power, the jurisdiction to hear any question respecting the interpretation of the Constitution, including the determination of the question whether anything said to be done under the authority of the Constitution or of any law is inconsistent with or in contravention of the Constitution. The judiciary, as a bastion of the rights of the people, is the safeguard and watchdog of the rights which are fundamental to human existence, security, and dignity. Whereas the court is mindful of the principle that the legislature has the power to legislate, and judges shall give deference to those words by keeping the balance and proportionality in the context of fast progressing issues of human rights, which have given birth to the enshrinement of fundamental rights in the Constitution. The Constitution should not represent a mere body or skeleton without a soul or spirit of its own. The Constitution, being a living tree with roots whose branches are expanding in natural surroundings, must have natural and robust roots to ensure the growth of its branches, stems, flowers, and fruits. And I refer to the case of Charles Lukeyen versus the Attorney General. Under what circumstances can the court grant conservatory orders? In Judicial Service Commission versus Speaker of the National Assembly and another, this court expressed itself as follows, and I quote, Conservatory orders, in my view, are not ordinary civil law remedies, but are remedies provided for under the Constitution, the supreme law of the land. They are not remedies between one individual as against another, but are meant to keep the subject matter of the dispute in situ. Therefore, such remedies are remedies in rem as opposed to remedies in personam. In other words, they are remedies in respect of a particular state of affairs as opposed to injunctive orders which may only attach to a particular person, unquote. This position was reinforced by the Supreme Court in the case of Gitirau Peter Munya versus Dixon Mwenda Gitinji, where the highest court in the land held, and I quote, conservatory orders bear a more decided public law connotation, for these are ordered to facilitate ordered functioning within public agencies as well as to uphold adjudicatory authority of the court in the public interest. Conservatory orders, therefore, are not, unlike interlocutory injunctions, linked to such private party issues as the prospects of irreparable harm occurring during the pendency of a case or highly probability of success in the applicant's case for orders of stay. Conservatory orders consequently should be granted on the inherent merit of the case, bearing in mind the public interest, the constitutional values, and the proportionate magnitudes and priority levels attributable to the relevant causes, unquote. Whereas it is true that in applications seeking to suspend legislation, care must be taken to ensure that the courts do not readily accede to the temptation to render legislation stillborn, and that such power ought not to be exercised lightly. To hold that the court can only grant conservatory orders where the court is satisfied that the challenge provisions are unconstitutional would, in my view, be stretching the standard too far. The law, as I understand it, is that in considering application for conservatory orders, the court is not called and is indeed forbidden from making any definitive finding, either of fact or law, as that is the province of the court that will ultimately hear the petition. At this stage, the first condition the applicant is required to establish is a prima facie case with a likelihood of success. What are the issues which the applicants intend to canvass at the hearing of this petition? It is contended that the process of enactment of the Act was itself unconstitutional, since it was not in accordance with the standing orders of the National Assembly. Article 109(3) and 4 of the Constitution provides, a bill not concerning county assembly is considered only in the National Assembly and passed in accordance with Article 122 of the standing orders of the Assembly. A bill concerning county government may originate in the National Assembly or Senate and is passed in accordance with Articles 110, Articles 122, 123, and standing orders of the Houses. It is contended by the petitioner that the issue whether or not a bill concerns county governments must, under Standing Order 122 of the National Assembly standing orders, be resolved before the first reading. According to the petitioners, from the correspondence on record, that resolution was purportedly made after the first reading, hence the standing orders were not adhered to. The respondent is, however, of the view that in light of the concurrence from the Speaker of the Senate that the amended bill giving rise to the Act in question did not concern county governments, that process cannot be faulted, since there ought to be substantive defects in the process to justify its invalidation. It was further contended that the manner in which the Act was passed was so chaotic and that it was infiltrated by strangers who may have shouted aye or nay. It was in fact described as a bogus process, as it generated into mayhem, chaos, and disorderly and shameful conduct. In opposition to the application, it was however contended that the mayhem was caused by the petitioners. Here, it must be stated that the petitioners are not all members of parliament. The second petitioner is in fact a constitutional commission. Hence, the contention that the mayhem was caused by the petitioners may not necessarily apply to the second petitioner, though it may apply to members of the first petitioner. In my view, if the process was shambolic, as it is alleged, it would not matter who caused the chaos, since Standing Order 98 places the duty of ensuring that order is maintained in the House squarely on the Speaker, which entails ensuring that pursuant to Standing Order 104, every member is seated at all times when in chamber, except when passing to or from his seat or when speaking. In Oloka, Onyango, and 9 others versus the Attorney General, it was held, and I quote, Parliament as a lawmaking body should set standards for compliance with the constitutional provisions and with its own rules. The Speaker ignored the law and proceeded with the passing of the Act. We agree with the Council of Pure that the enactment of the law is a process, and if any of the stages therein is flawed, that vitiates the entire process and the law that is enacted as a result of it. We have therefore no hesitation in holding that there was no quorum in Parliament when the act was passed, and the Speaker acted illegally in neglecting to address the issue of quorum. Failure to obey the law or rules rendered the whole process a nullity. It is an illegality which this court cannot sanction, unquote. It was further contended that the bill in question was a bill concerning county governments since it touched on security. At paragraph 102 of the decision in the Speaker of the Senate versus the Attorney General, the Supreme Court held, and I quote, "The course of observation in the matter of interim independent electoral commission is borne out in an official publication, final report of the task force on devolved government. That the extent of the legislative role of the Senate can only be fully appreciated if the meaning of the phrase concerning counties is examined. Article 110 of the Constitution defines bills concerning counties as being bills which contain provisions that affect the functions and powers of the county governments as set out in the 4th schedule. Bills which relate to the election of members of the county assembly or county executive, and bills referred to in chapter 12 as affecting finances of the county governments. This is a very broad definition which creates room for the Senate to participate in passing of bills in the exclusive functional areas of the national government, for as long as it can be shown that such bills have provisions affecting the functional areas of the county governments. For instance, it may be argued that although security and policing are national functions, how security and policing services are provided affects how county governments discharge their agricultural functions. As such, a bill on security and policing will be a bill concerning counties. With a good speaker, the Senate should be able to find something that affects the functions of the counties in almost every bill that comes to Parliament, making it a bill that must be considered and passed by both houses, unquote. It was, however, contended that the Speaker of the Senate, having expressed concurrence that the bill did not concern county governments, that was the end of the matter, and there was no need for the Senate to deliberate further on the same. At paragraph 131 of the above case, the Supreme Court held, and I quote, "Where the speakers determine that a bill is not one concerning county governments, such a bill is then rightly considered and passed exclusively by the National Assembly and then transmitted to the President for assent. The emerging broader principle is that both chambers have been entrusted with the people's public task, and the Senate, even when it has not deliberated upon a bill at all the relevant stages, has spoken through its speaker at the beginning and recorded its perception that a particular bill rightly falls in one category rather than the other. In such a case, the Senate's initial filtering role, in our opinion, falls well within the design and purpose of the Constitution and expresses the sovereign intent of the people. This cannot be taken away by either chamber or either speaker thereof," unquote. From the above holding, it would seem that if the Speaker of the Senate signifies concurrence with the bill, that it falls within one category or another, it may well be said that that is the end of the matter. However, the petitioner's case that there was no such concurrence since the Speaker of the Senate used the words "may not." It was further contended that there was no public participation before the bill was passed, and the 5 days period was not sufficient to enable Kenyans to express their views on the extensive complex amendments. In the case of Robert N. Gakuru and others versus the Governor, Kiambu County and another, this court cited with approval the decision in Glenister versus President of the Republic of South Africa, where it was held in the earlier as follows, and I quote, "For the opportunity afforded to the public to participate in the legislative process to comply with Section 118(1), the invitation must give those wishing to participate sufficient time to prepare. Members of the public cannot participate meaningfully if they are given inadequate time to study the bill, consider their stance, and formulate representations to be made. Two principles may be deduced from the above statement. The first is that the interested parties must be given adequate time to prepare for a hearing. The second relates to the time or stage when the hearing is permitted, which must be before the final decision is taken. These principles ensure that meaningful participation is allowed. It must be an opportunity capable of influencing the decision to be taken. The question whether the notice given in a particular case complies with these principles will depend on the facts of that case," unquote. As was held in the case of Doctors for Life International, merely to allow public participation in the lawmaking process is, in the prevailing circumstances, not enough. More is required. Measures need to be taken to facilitate public participation in the lawmaking process. Thus, Parliament and the provincial legislatures must provide a notice of and information about the legislation under consideration and opportunities for participation that are available. To achieve this, it may be desirable to provide public education that builds capacity for such participation. Public involvement in the legislative process requires access to information and the facilitation of learning, understanding in order to achieve meaningful involvement by ordinary citizens. The Assembly should create conditions that are conducive to the effective exercise of the right to participate in the lawmaking process. This can be realized in various ways, including through road shows, regional workshops, radio programs, and publications aimed at educating and informing the public about ways to influence Parliament, to mention a few. It is implicit, if not explicit, from the duty to facilitate public participation in lawmaking process that the Constitution values public participation in the lawmaking process. The duty to facilitate public participation in the lawmaking process would be meaningless unless it sought to ensure that the public participate in that process. The very purpose in facilitating public participation in legislative and other process is to ensure that the public participates in lawmaking process consistent with our democracy. Indeed, it is apparent from the powers and duties of legislative organs of state that the Constitution contemplates that public will participate in the lawmaking process. In determining whether the Parliament has complied with this duty to facilitate public participation in any particular case, the court will consider what Parliament has done in that case. The question will be whether what Parliament has done is reasonable in all of the circumstances. And factors relevant to determining reasonableness would include rules, if any, adopted by Parliament to facilitate public participation, the nature of the legislation under consideration, and whether the legislation needed to be enacted urgently. Ultimately, what Parliament must determine in its case is what the methods of facilitating public participation would be appropriate. In determining whether what Parliament has done is reasonable, this court will pay respect to what Parliament has assessed as being the appropriate method. In determining the appropriate level of scrutiny of Parliament's duty to facilitate public involvement, the court must balance, on one hand, the need to respect parliamentary institutional autonomy, and on the other, the right of the public to participate in public affairs. In my view, this balance is best struck by this court considering whether what Parliament does in each case is reasonable. In the case of Matatiele Municipality and others versus the President of the Republic of South Africa, the court discussed what public participation may attain and expressed itself as follows, and I quote: "This may include providing transportation to and from hearings or hosting radio programs in multiple languages on an important bill, and may well go beyond any formulaic requirements of notice or hearing. In addition, the nature of the legislation and its effect on the provinces undoubtedly plays a role in determining the degree of facilitation that is reasonable and the mechanisms that are most appropriate to achieve public involvement. Thus, contrary to the submissions of the government, it's not enough to point to standing rules of legislature that provide generally for public involvement as evidence that public involvement took place. What matters is that the legislature acted reasonably in the manner that it facilitated public involvement in the particular circumstances or given case. The nature and the degree of public participation that is reasonable in a given case will depend on a number of factors. These include the nature and the importance of legislation and the intensity of its impact on the public. The more discrete and identifiable the potentially affected section of the population, and the more intense the possible effect on the interest, the more reasonable it would be to expect the legislature to be astute to ensure that the potentially affected section of the population is given a reasonable opportunity to have a say. In the instant case, it is alleged that when the bill was published on 8th of December 2014, the same was only made available to the public on 9th of December 2014 through the limited use of digital technology only, and at the tight timeline given by the Departmental Committee on Administration and National Security for making submissions, the sheer volume of the bill and the difficulty in accessing the bill seriously limited public participation and made it impossible for any meaningful public participation and engagement with the bill. It was contended that the amendments made to the various pieces of legislation by the Act are major amendments that have had the cumulative effect of eroding the Bill of Rights and other articles in violation of the Constitution. One such amendment was introduced by Clause 16 of the Act and is to the effect that in specified offenses, the prosecution may, with the leave of court, not disclose certain evidence on which it intends to rely until immediately before the hearing. This is impugned on the ground that it violates the spirit of Article 52J of the Constitution, which decrees that every accused person has the right to fair trial, which includes the right to be informed in advance of the evidence the prosecution intends to rely on and to have reasonable access to that evidence. It is arguable where the furnishing of witness statements immediately before hearing is the information in advance of the evidence the prosecution intends to rely on. If it is not, then the next issue would be whether it is a limitation, and if so, whether it has the effect of limiting the right so far as to derogate from its core or essential content. The same position applies to clause 15, and whether it contravenes the letter and or the spirit of the rights enshrined under Articles 49 and 50 of the Constitution with respect to arraignment in court, charge, and expeditious trial. One of the considerations which the court hearing the petition will have to determine, if it finds that the amendments amount to limitation of fundamental rights and freedom, will be the relation between limitation and its purpose, and whether there are less restrictive means to achieve the purpose. According to the petitioners, the crisis of insecurity afflicting our country is not due to a dearth of relevant laws to combat insecurity, but rather due to lack of effective implementation of the law by the relevant security actors and agencies, mostly due to other factors like endemic corruption prevalent within the security agencies. If that position is found to be correct, then the court may well find that there are less restrictive means to achieve what is intended to be achieved by the amendments. That, however, is not a matter for today. With respect to the amendment limiting the number of refugees to a maximum of 150,000 unless increased by Parliament, it was contended that such an amendment contravenes the international conventions and instruments which form part of our domestic law by virtue of Article 2, 5, and 6 of the Constitution. I have identified only some of the issues raised by the petitioners. In my view, these are not frivolous issues. To the contrary, they are weighty constitutional issues which require to be investigated further by the court. To demonstrate that the respondent and the duly appreciated this, they sought a certification under Article 165.4 of the Constitution. However, there's a difference between a matter which raises prima facie case and one which raises substantial question under Article 165.4 of the Constitution. In my view, the decision whether or not to impanel a bench pursuant to Article 165.4 of the Constitution ought to be made only where it is absolutely necessary and in strict compliance with the relevant constitutional and statutory provisions. In this country, we still do not have the luxury of granting such orders at the whims of the parties. Judicial resources in terms of judicial officers in this country are very scarce. Impaneling the bench usually a consequence of delaying cases which are already on the queue, hence worsening the problem of backlog in this country. As was appreciated by Majanja Jai in the case of Harrison Kinyanjui versus Attorney General, the meaning of substantial question must take into account the provisions of the Constitution as a whole and the need to dispense justice without delay, particularly given specific fact situations. Article 165 of the Constitution provides, and I've reproduced it in full. From the foregoing, it is clear that the only constitutional provision that expressly permits the constitution of a bench of more than one High Court judge is Article 165.4, under which the judge is enjoined to certify that the matter raises substantial question of law. 1, whether a right of fundamental freedom in the Bill of Rights has been denied, violated, infringed, or threatened, or 2, that it involves a question respecting the interpretation of this Constitution, and under this is included the question whether any law is inconsistent with or in contravention of the Constitution. 2, the question whether anything said to be done under the authority of the Constitution or any other law is inconsistent with or in contravention of the Constitution. 3, any matter relating to constitutional powers of state organs in respect of county governments and any matter relating to the constitutional relationship between the levels of government. And 4, a question relating to conflict of laws under Article 191. Therefore, it's not enough that the matter raises the issue whether a right of fundamental freedom in the Bill of Rights has been denied, violated, infringed, or threatened, or that it raises the issue of interpretation of the Constitution. The court must go further and satisfy itself that the issue also raises a substantial question of law. The Constitution itself does not define what constitutes substantial question of law. It is therefore upon the court to determine what would amount to a substantial question of law. I am guided on this aspect by the decision in the case of Chunilal v. Mehta versus Century Spinning and Manufacturing Company, where it was held, and I quote, "A substantial question of law is one which is of general public importance, or which directly or substantially affects the rights of the parties and which have not been finally settled by the Supreme Court, the Privy Council, or the Federal Court, or which is not free from difficulty, or which calls for discussion of alternative views. If the question is settled by the highest court or the general principles to be applied in determining the question are well settled, and there is a mere question of applying those principles, or that the plea raised is palpably absurd, the question would not be substantial, unquote. In the case of Santosh Hazari versus Purushottam Tiwari, it was held, and I quote, a point of law which admits of no two-point opinions may be a proposition of law, but cannot be a substantial question of law. To be substantial, a question of law must be debatable, not previously settled by law of the land or a binding precedent, and must have a material bearing on the decision of the case, if answered either way, insofar as the rights of the parties before it are concerned. To be a question of law involving in the case, there must be first a foundation for it laid in the pleadings, and the question should emerge from the sustainable findings of fact arrived at by court of facts, and it must be necessary to decide that question of law for a just and proper decision of the case. An entirely new point raised for the first time before the High Court is not a question involved in the case unless it goes to the root of the matter. It will therefore depend on the facts and the circumstances of each case whether the question of law is a substantial one and involved in the case or not. The paramount overall consideration being the need for striking a judicious balance between the indispensable obligation to do justice at all stages and impelling necessity of avoiding prolongation in the life of any lease, unquote. In India, certain tests have been developed by the courts as criterion for determining whether a matter raises a substantial question of law, and these are: 1, whether directly or indirectly it affects substantial rights of the parties, or 2, whether the question is of general public importance, or 3, whether it is an open question in the sense that the issue has not been settled by pronouncement of the Supreme Court or the Privy Council or by the Federal Court, or 4, the issue is not free from difficulty, or 5, it calls for discussion for alternative view. In my view, these holdings offer proper guidelines to our court in determining whether or not a matter raises a substantial question of law for the purpose of Article 165 of the Constitution. Other factors which the court may consider, in my view, include whether the matter is moot, in the sense that the matter raises a novel point, whether the matter is complex, whether the matter by its nature requires a substantial amount of time to be disposed of, the effect of the prayer sought in the petition, and the level of public interest generated by the petition. However, since the article employs the word includes, to my mind, that list is not exhaustive. The decision whether to certify that a matter raises a substantial question of law, whether the right of fundamental freedom on the Bill of Rights has been denied, violated, infringed, or threatened, or is in respect of the interpretation of the Constitution being a judicial determination. The mere fact that parties agree that the matter ought to be certified does not bind the court. It is, however, incomprehensible to me to reconcile the submission that the matter before the court raises no prima facie arguable issue, and in the same breath contend that the matter in fact raises a substantial question of law as contemplated under Article 165(4) of the Constitution. In these petitions, I am, however, satisfied that the issues raised herein disclose substantial questions of law, as what is at stake is the balancing of the need to secure the country on one hand and the protection of the Bill of Rights on the other, both of which the state is enjoined to attain. However, apart from establishing prima facie case, the applicant must further demonstrate that unless the conservatory order is granted, there is real danger which may be prejudicial to him or her. See the case of Center for Rights Education and others versus Attorney General. In the Privy Council case of Attorney General versus Bansraj, the court held, and I quote, now to the formula, both remedies of interim injunction and interim declaration orders are excluded by the State Liability and Proceedings Act as applied by Section 14(2) and 3 of the Constitution and also by high judicial authority. The only judicial remedy is that of what has become to be known as conservatory order in the strictest sense of that term. The order would direct both parties to undertake that no action of any kind to enforce their respective right will be taken until the substantive originating motion has been determined. That the status quo of the subject matter will remain intact, the order would not then be in the nature of an injunction, but on the other hand, it would be well within the competence and jurisdiction of the High Court to give such directions as it may consider appropriate for the purpose of securing enforcement of the provisions of the Constitution. In the exercise of discretion given under Section 14(2) of the Constitution, the High Court would be required to deal expeditiously with the application inter partes and not inter partes, and to set down the substantive motion for hearing within a week at most of the interim conservatory order. The substantive motion must be heard forthwith and the rights of the parties determined. In the event of an appeal, priority must be given to the hearing of the appeal. I have suggested this formula because, in my opinion, the interpretation of the word in Section 14(2), subsection 3, and the enactment of Section 14.3 in the 1976 Constitution must have the effect, without a doubt, of taking away from the individual the redress of injunction which was open to him under the 1962 Constitution. On the other hand, however, the state has its rights too. The critical factor in cases of this kind is the exercise of discretion of the judge, who must hold the scales of justice evenly, not only between man and man, but also between man and the state, unquote. Therefore, said principles were adopted by the High Court of the Republic of Trinidad and Tobago in the case of Steve Ferguson and another versus Attorney General, where it was held. I have considered the principles of East Coast drilling, and I adopt the reasoning of Banstrad and consider it appropriate in this case to grant a conservatory order against the extradition of the claimants pending the determination of this motion. The constitutional challenge to the act made in this case is on its face a serious one. The defendant has not submitted the constitutional claim is unarguable. The claimants contend that the act is in breach of a fundamental law and the international obligations undertaken were inconsistent with supreme law. It would be wrong, in my view, to extradite the claimants while this issue is pending in effect, and which will render the matter of the constitutionality of the legislation academic, unquote. Musain Ajay, in the case of Center for Rights and Education Awareness, said, it is important to point out that the arguments that were advanced by counsel and that I will take into account in this ruling relate to the prayer for conservatory orders in terms of prayer 3 of the petition application and not the petition. I will therefore not delve in a detailed analysis of facts and law. At this stage, a party seeking a conservatory order only required to demonstrate that he has a prima facie case with the likelihood of success, and that unless the court grants the conservatory order, there is real danger that he will suffer prejudice as a result of violation or threatened violation of the Constitution. In the Center for Human Rights and Democracy versus the Judges Magistrate Vetting Board, it was held by a majority as follows. In our view, where legal wrong or legal injury is caused to a person or to a determined class of persons by reason of violation of any constitutional or legal right, or any burden is imposed in the contravention of any constitutional or legal provision, or without the authority of the law, the High Court has power to grant appropriate relief so that the aggrieved party is not rendered helpless or helpless in the eyes of the wrong visited or about visited upon him or her. This is meant to give an interim protection in order not to expose others to preventable perils or risks by inaction or omission, unquote. In this case, whereas the second petition 6 that the entire act be suspended, the first petition 6 for the suspension of only some of the articles. The respondent took an issue with this and contended that since only some of the articles are sought to be suspended, it means that the petitioner's allegation of unconstitutionality of the act is untenable. With due respect, this position cannot be correct. From the authorities cited herein and in my own holding herein above, the power to suspend legislation during peacetime ought to be exercised with care, prudence, and judicious wisdom, where it is shown that the operation of the legislative provisions are a danger to life and limb, and there is imminent danger to the Bill of Rights at that very moment, and where the national interest demand. This is in consonance with the principle that a law is only void if inconsistent with the Constitution to the extent of its inconsistency. In my view, what the drafters of the Constitution intended is that the court, in determining the constitutionality of an enactment, ought to adopt what I would call a guided missile approach, so as to target only the offensive parts of the act, lest the court, under the guise of determining constitutionality of an act, be guilty of usurpation of legislative mandate of the legislature if it were to nullify the whole legislation simply because of a few offensive provisions. By parity of reasoning, it is only those provisions which disclose danger to life and limb or imminent danger to the Bill of Rights. At that moment, the court can be justified in suspending by way of conservatory orders. I must, however, make it clear that the mere fact that the court suspends certain provisions of the challenged enactment does not amount to a determination that those provisions are unconstitutional. In other words, there is no inconsistency in the court granting conservatory orders, suspending certain provisions, and after hearing the petition, finding that the same provisions are, after all, not unconstitutional. Similarly, there is no inconsistency in the court invalidating provisions which, at the hearing of the application for conservatory orders, it did not find necessary to suspend. In other words, at this stage, this court is not entitled to determine the petition in its entirety. I now proceed to examine the clauses sought by the petitioner to be suspended. Clause 4 of the Act introduced an amendment replacing the words deleting the words Commissioner of Police or Provincial Commissioner, and substituting therefore the words Cabinet Secretary on the advice of Inspector General of the National Police Service with respect to declaration of curfew. Apart from that, it enhances the fine to Kenya shillings 10,000 from Kenya shillings 1,000. In my view, there is no imminent threat which cannot await the hearing of the petition. Similarly, clause 5 only has the effect of substituting province with county, commissioner of police with cabinet secretary, and reflects enhanced fine. Again, I see no reason to suspend the same. Clause 12 for the Act introduces a clause which limits the freedom of expression and freedom of the media, and imposes a hefty fine of Kenya shillings 5 million for the offenders, or 3 years in prison, or both. If implemented, there is imminent danger of the offenders losing their liberty. Clause 15 of the Act, though not specifically mentioned by the first petitioner, was challenged by the petitioners on the ground that it permits the keeping in custody of a suspect for a period of 90 days. Since that provision is subject to a court order, I do not see the justification for suspending it at this stage. Clause 16 has the effect of denying the accused person evidence sought to be presented against him until just after the hearing. As already discussed above, it is arguable whether this negates the spirit of Articles 49 and 50 of the Constitution. It must be remembered that Article 50 of the Constitution is one of the protected articles by Article 24, hence cannot be limited. If the court was to find that this provision is unconstitutional, the criminal process in this country will face a crisis with respect to persons whose trial were rendered unfair as a result of this clause. Clause 25 empowers the registrar of persons to cancel registration or revoke identity cards under specified circumstances. Whereas the amendment is on the face of it a limitation of the rights enshrined under Article 12 of the Constitution, the amendment seems to provide for due process to be followed before cancellation or revocation. Accordingly, I do not see any immediate danger which cannot await the hearing of the petition. Clause 26 of the Act introduced an admission of statement by consent in criminal trials. This amendment is objected to as contravening Article 52L with respect to self-incriminating evidence. The DPP is of the view that this amendment does not add anything new to current criminal process. Similarly, if convictions were to be based on this provision and the court was to find that the same is unconstitutional, it would similarly lead to a crisis. Clause 29 seems to introduce summary procedure in criminal proceedings by introducing proof by way of notice, though it is called agreement. Similar constitutions to the foregoing provision apply. Whereas nothing turns on Clause 35A, Clause 35B seems to enlarge the definition of firearm to include telescopes and night vision devices, and outlaws the manufacture, assembling, purchase, acquisition, or possession of an armored vehicle without approval. I am not satisfied that there is any imminent danger that cannot await the hearing of the petitions. Hence, there is no justification to suspend this clause at this stage. Clause 48 introduces a ceiling on the number of refugees and asylum seekers permitted to be in the country and places it at 150,000, though the same can be varied for a maximum of 12 months by Parliament. It is contended that this provision flies in the face of the international instruments which are part of our law by virtue of Article 2, 5, and 6 of the Constitution, in particular, Convention and Protocol relating to status of refugees 1951, International Covenant on Civil and Political Rights 1966, and United Nations Universal Declaration of Human Rights 1948, as well as the African Charter on Human and People's Rights. The effect of implementation of this amendment would be the immediate reduction of the number of refugees, which may lead to evacuation of some of them from the refugee camps and the deportation of not a small number of refugees from the country if the second petition contention that there were 583,273 refugees as at 30th of November 2014 is to be believed. If this was to happen before the petitions are heard, nobody, including the Line Solicitor General, was able to enlighten the court how the situation would be restored. Clause 56 introduced new Part 5 dealing with special operations, which are operations meant to neutralize threats against national security. The provisions thereunder then proceed to deal with what are called covert operations. It is contended that this provision is likely to take the country back to the pre-2010 Constitution dark days. By enacting unto themselves the current Constitution by way of a referendum, no doubt Kenyans intended to have a break from the past. It is therefore necessary that this part be investigated by the court in order to determine whether it is susceptible to abuse considering the current constitutional dispensation. Clause 58 seeks to replace Parliament with the National Assembly, effectively removing the Senate from playing oversight role on the National Intelligence Service. This provision is objected to as having been inserted without recourse to the Senate. Again, the jury is still out on the question of the Senate's role in the enactment of the Act. Clause 64 introduced an offense of publication of offending material, which is defined as publication or statement that is likely to be understood as directly or indirectly encouraging or introducing another person to commit or prepare to commit an act of terrorism. That terrorism is a serious problem in this country and that the menace has led to loss of lives, limbs and property is an understatement. Any Kenyan of goodwill, in my view, must support all the lawful steps being taken by the government to contain the terrorism menace in this country. Such steps, if lawful, ought to be applauded by all state organs in this country. Faced with similar menace, India enacted Prevention of Terrorism Act 2002, otherwise known as POTA, which was challenged on its constitutional validity. In a decision in the People's Union for Civil Liberties and another was Union of India, the Supreme Court of India recognized that, and I quote, in deciding the point of legislative competence, it is necessary to understand the conceptual backdrop that led to the enactment of POTA, which aims to combat terrorism. Terrorism has become the more worrying feature of the contemporary life. Though violent behavior is not new, the present-day terrorism in its full incarnation poses extraordinary challenges to civilized world. The basic edifices of a modern state like democracy, state security, rule of law, sovereignty and integrity, basic human rights, etc., are under the attack of terrorism. Though the phenomenon of terrorism is complex, a terrorist act is easily identifiable when it does occur. The core meaning of the term is clear, even if its exact frontiers are not. Our country has been the victim of an undeclared war by the epicenters of terrorism with the aid of well-knit and resourceful terrorist organizations engaged in terrorist activities in different states. To face terrorism, we need new approaches, techniques, weapons, expertise, and of course, new laws, unquote. I dare say that the grim picture portrayed in the above decision is exactly what we are confronted with in this country, and the government is obliged to take all lawful measures to nip acts of terrorism in the bud, and such measures ought to be supported by Kenyans of all walks of life. Such moves, however, must pass constitutional and legal muster. Even the Supreme Court of India appreciated this when it pronounced, and I quote, the protection and promotion of human rights under the rule of law is essential in the prevention of terrorism. Here comes the role of law and the court's responsibility. If human rights are violated in the process of combating terrorism, it will be self-defeating. Terrorism often thrives where human rights are violated, which adds the need to strengthen action to combat violations of human rights. The lack of hope for justice provides breeding grounds for terrorism. Terrorism itself should also be understood as an assault on basic rights. In all cases, the fight against terrorism must be respectful to the human rights. Our Constitution laid down clear limitations on the state actions within the context of the fight against terrorism. To maintain this delicate balance by protecting core human rights is the responsibility of the court in a matter like this, unquote. It will be the mandate of the court at the hearing of the petition to determine whether the provisions of the Act met the constitutional validity. Having read Clause 64 of the Act, it is my view that the new Section 30A of the Prevention of Terrorism Act requires further interrogation by the court. These provisions may prima facie infringe upon freedoms and fundamental rights. Similarly, Section 30F of the same Act, which prohibits broadcast, ought to be interrogated further by this court before implementation. Objection was taken further to Clause 86, which empowered the President to nominate the Inspector General of Police. In other words, the amendment removes the role of National Police Service Commission from the appointment of the Inspector General. Whereas that may be a contentious issue, I am not satisfied it poses any danger which cannot await the hearing of the petitions. If after the hearing of the petition the court finds that the said amendment is unconstitutional, I do not see any difficulty in the court making appropriate orders to rectify that situation. This court was urged not to grant the order sought on the ground that in the recent past there has been a lot of judicial bashing from other organs of the state, and that the court may be construed as engaging in judicial activism. On this point, I can do no better than cite the decision in Kinyanjui versus Kinyanjui, where it was held, for a court of law to shirk from its constitutional duty of granting relief to a deserving suitor because of fear that the effect would be to engender serious ill will and probable violence between the parties, or indeed any other consequences, would be to sacrifice the principle of legality and the dictates of the rule of law at the altar of convenience, as would be to succor and sustenance to all who can threaten with sufficient menaces that they cannot live with and under the law. It has been said that the courts must never shy away from doing justice, because if they did not do so, justice has the capacity to proclaim itself on the mountaintops and to open up the heavens for it to rain down on us. Courts are the temples of justice and the last frontier of the rule of law. Justice, it has been said, is not a cloistered virtue, and that where justice is done and public interest upheld, it is acknowledged by the public at large. The sons and daughters of the land dance and sing, and the angels of heaven sing and dance, and heaven and earth embrace. Before I apart from this ruling, I wish to express my gratitude to counsel who appeared in these proceedings for the well-researched submissions, which I found very useful and which I have considered. If I have not expressly referred to each and every authority cited, it's not out of disrespect or lack of appreciation for their industry. In the result, I grant conservatory orders suspending the following clauses in the Security Laws Amendment Act number 19 of 2014, together with the amendments with respective statutes, pending the hearing and determination of these petitions. 1, Clause 12, which inserted Section 66A to the Penal Code. 2, Clause 16, which inserted Section 42A to the Criminal Procedure Code. 3, Clause 26, which inserted Section 20A to the Evidence Act. 4, Clause 29, which inserted Section 59 to the Evidence Act. 5, Clause 48, which inserted Section 16A to the Refugees Act. 6, Clause 56, which repealed and substituted Part 5 of the National Intelligence Service Act. 7, Clause 58, which amended Section 65 of the National Intelligence Service Act by deleting the word Parliament and substituting therefore the word National Assembly. And 8, Clause 64, to the extent that it introduces Sections 30A and 30F of the Prevention of Terrorism Act. Pursuant to Article 165.4 of the Constitution, I hereby certify that these petitions raise substantial question of law under Clause 3B and D of Article 165. Accordingly, I direct that these petitions be transmitted to the Honorable the Chief Justice forthwith for purpose of impaneling an even bench of not less than 3 judges assigned by him to hear and determine the petitions. The course of these applications shall be in the course, and it is so ordered.
Much obliged.
Mr. Njoroge, you have an application?
Yes, my lord.